All right, I'm pleased to welcome our two speakers today. First, to my immediate left, Paula Frederick. Paula was recently named General Counsel for the State Bar of Georgia, a unified bar organization with 41,000 members. The Office of General Counsel is responsible for interpreting the ethics rules for lawyers, prosecuting lawyer discipline cases, and providing legal advice to the officers and directors of the State Bar. Ms. Frederick is a graduate of Vanderbilt University School of Law and a graduate of Duke University. Prior to joining the Office of the General Counsel, she spent 6 years as a staff attorney with the Atlanta Legal Aid Society, handling civil matters for low-income people. She is a past president of both the Atlanta Bar Association and the Georgia Association of Black Women Attorneys. She is also an active member of the American Bar Association, where she currently sits in the House of Delegates and on the Standing Committee on Ethics and Professional Responsibility. Next to Paula is Miriam Krinsky. She is a lecturer at the UCLA School of Public Policy and also an adjunct professor at Loyola Law School. She is a member of the California Blue Ribbon Commission on Foster Care, the California Judicial Council, the leadership body for the state's judicial branch, and numerous other federal, state, and local policy groups. Ms. Krinsky served for 5 years as the executive director of and special director of policy and reform initiatives for the Children's Law Center of Los Angeles, a 185-person nonprofit organization that represents over 20,000 abused and neglected youth in Los Angeles, and thereafter worked with California government leaders to help launch the state's Child Welfare Council. Ms. Krinsky has lectured nationwide and testified extensively before legislative, governmental, and judicial bodies on issues relating to children at risk, the criminal justice system, and sentencing and appellate practices. She has authored over 50 articles on foster care, juvenile justice, and criminal law issues. Please join me in welcoming Miriam and Paula.
Well, thank you. Thank you for the introduction. It was wonderful to get to at least see the dean here, who seems quite distinguished, and thanks to all of you for showing up. I know that there is exciting legislative activity going on today. Frankly, I wish I were there. I would have loved to be there. I don't know if anybody by cell phone is keeping track of how it's going, but if so, you can sort of show us thumbs up, thumbs down, or in between. But I know that all of you must be hopefully dedicated to this learning experience in that you're here and not there. I will give one last pitch for anybody who wants to move forward in teaching both my graduate students and law students. I always tell them more participation points are given out in front. That doesn't always work. Usually the back row tends to fill first. I realize we don't have participation points here, but maybe I should say more MCLE credits are given out in front. Perhaps that'll help. So having greatly succeeded in that effort, I see we'll be looking to the back for some of the conversation as well. But again, it is truly wonderful to be here, having worked over time with Karen Worthington, having corresponded via email with Michelle Barclay and others in the state, and having sat on an ABA commission together on youth at risk with Paula. It is terrific to have a chance to intersect one more time with these wonderful individuals. As you heard, I come from California, and oftentimes I wonder what credibility we can bring to any conversation about struggling children and families. Our state just discovered in a story that came out 2 days ago that we are now another $21 billion in the hole. So having made some huge cuts to services and support for children and families last year, and having thought that the bleeding was over, we now, I don't know how, need to go through that process anew. So I do wonder at times whether I can be bringing a sensible or credible voice given the mess in my own state. But I have now traveled to many parts of the country in work that I've done with the ABA, talking about this subject and others. And having been throughout the country, what I've seen are sort of two takeaways. One is it's bad all over, and I think that's probably no news for all of you here. We certainly know that the federal picture is one of tremendous challenge. all states, some may not be quite as dismal or as dismally situated as California, but I think all states are struggling right now. But the second thing I've seen, which is the more positive part of that, is that throughout the country, it's impressed me with the tremendous and enduring passion and commitment that professionals are bringing to this work. I think that view of we're just going to have to do more with less really is taken to heart throughout the country. And it's given me tremendous hope that when we do surface, as we will surface from this fiscal challenge, that the wonderful professionals in this field are going to finally feel like the clouds have parted and the sunshine's coming through, but no one seems to be giving up on doing that much more for families and children who need us that much more as we're trying to keep the ship steadied over these times. So you heard a little bit of my background, and I think I might add one or two words to it in just a minute, but just so we have a sense of all of you who are sharing your time with us over the next couple of hours, if I could just see by show of hands, how many lawyers do we have in the room? Okay, just about everyone. So, and how many of you are lawyers who represent parents? Okay, one sort of sheepishly in the back, kind of not sure, but she's willing to raise her hand. How many of you represent children? Okay, you're sort of collected together in the middle, I see. How many of you represent your Department of Family and Children's Services? Okay, on our bookends. And how many of you are lawyers but don't do this work at all and just happen to see the free sandwiches? No? Okay, it's a sandwich guy in the back. Okay, he gets all the tough questions since he was willing to raise his hand to that. Any judges with us? Now, hopefully they also were lawyers, but no judges. Okay. And any child welfare professionals who come from outside the law? Social workers, probation officers, yes. And you are, okay. Okay, and anyone else, any students? Okay, good. She's the one who's typing or on Facebook. No. Okay, she's taking notes, all right. My older daughter, who's now a college sophomore, has come and sat in on my classes, and you know, I don't walk around the room because it's sort of a U-shaped classroom that I teach my seminar in, and she sat in the back of the room and said, "Mom, they're not taking notes, they're all on Facebook." So I don't think all was fair, but certainly now I wander the class much more. But I'm sure she's not on Facebook. Any academicians or anybody from, okay, so he was the one who wanted the free sandwiches. So let me add one other element to the background that was given, and I think both the attempt was to abbreviate the background because I made clear my view was don't introduce us, let us get into the substance rather than time on us. But I think she intentionally skipped the middle paragraph, which is just in full disclosure. Before I came over the last 10 years to the child advocacy, child welfare arena, I spent 15 years in sort of the unlikely feeder into child advocacy, namely as a federal prosecutor. And I tell you that not to hopefully get booed out of the room, but to just give you a sense that I think in some ways what I saw in those 15 years, and during a period of time when we were very much in the tough on crime sort of 80s mindset, but I think I spent that period of time seeing the end product of a failure to do right by children, the sort of slippery slope that too many youth fall down if we don't catch them while they're part of the child welfare system, and saw as in my time as a federal prosecutor and doing policy work as well in DC that too often when they fall down that slope, they face unforgiving sentences, inflexible sentences in the federal system, and it's that much more critical for us to seize the windows of opportunity when we can. Now, as you heard, I'm in the teaching world, so I say that to let you know that, one, I'm used to being interrupted. I like being interrupted, and while the first part of this discussion is going to be a little bit more presentation focused, we very much want in the second part as much as possible to get you involved. I also have 2 teenage daughters, so they interrupt all the time. So let me just assure you that anything you want to say or throw at us will not be as difficult as I get from my teenagers half the time. So with that, let me launch ahead. And you might have observed that my PowerPoint is punctuated by artwork, not this particular slide. The scales were not drawn by anyone other than probably some digital program, but much of my presentation does have artwork. It's all artwork of youth from around the country in our foster care system at the time that they did the artwork. I think it's wonderful, and I like any opportunity I can get to have the chance to show it around the country. So during the course of this presentation, I think there are really 2 parts and 2 areas that we plan to cover. The first part is to look at the multiple dimensions of the issue of children in the courtroom. Should we include them? How do we include them? What are the benefits of including them? What are the challenges of including them in the court and the legal process? What does the national picture look like? Is it the norm? And where are the trend lines in that area? What federal laws, and I'll even touch briefly on what international perspectives are there on the issue of whether children need to be part of the court and the legal process, and how does that legal backdrop fit in? And then the second part, which is where Paula and I will both be participating and hopefully engaging all of you in our conversation as well, is to look at some of the ethical issues that overlay the issue of bringing children into court. And that's sort of an added dimension that has been added more recently to this presentation that I and others are doing on behalf of the ABA. I think what we realized is not simply that if you give ethics credits, they will come, but that there are ethical issues that are inherently intertwined with the question of bringing children to court. And unless we start to try to talk about them, grapple with them, and understand that there are no often right or wrong answers, there are simply shades of gray that we need to work our way through, that we're not really doing justice to this topic. So that's kind of the rundown for the next couple of hours. So before getting into those ethical issues, I do want to do a bit of a scan about how does some of the policy look like in this area? What are some of the attitudes in this area? We know that there are passionate views on all sides of the issue of bringing children to court. Some of the most passionate perspectives come from the youth themselves, who make clear just how deeply they care about being present and being engaged in the process, and who also are very quick to point out that when they aren't part of the process, that feeling of exclusion and hurt and isolation is one that may stay with them from years to come. Often the experiences of Lewis, who is quoted on this slide, are the norm. Children at a young age very commonly are taken out of their home, removed from everything that's familiar to them, very often, more often than I think all of us would care for, are separated from their siblings, often moved from school to school, from placement to placement. And throughout that process, it's not uncommon for them to have no idea what's happening, why it's happening, who's making the decisions, or what's coming next. Now, I think the natural response might be, so we need to do a better job keeping youth informed. We need to tell them what's going on and where things are going to be going next, potentially. And if we do that, why do they need to be in court? What's so important about the court process? A national body, the Pew Commission on Children in Foster Care, a couple of years ago, looked at a couple of areas of reform in child welfare, federal funding of child welfare, as well as the court and the legal process. And interestingly, one of the areas of recommendation of that national body was that children need to be not simply kept abreast of what's going on, but they need to be physically present in the courtroom. And in making that recommendation, that commission focused on the fact that the court really stands in that critical shoes of sort of the gatekeeper and the Uber parent. That the court, as we all know, decides whether a child's going to come into care, when and if they'll exit care, whether parental rights will be terminated, and all of the key decisions that might happen in between. We also know, if we look beyond our dependency courts, that generally when we ask litigants about how do you feel about the court process, a very California type question, how do you feel about anything? But certainly surveys have been done around the country about how people feel about the court and the legal process. And what we find in survey after survey along those lines is that participants generally tell us that what matters to them as much as the result, and in some cases people even identify this higher than the actual outcome, is a feeling of having been treated fairly. That a fair and inclusive process, being treated with respect, feeling like they've been heard, is something that will not simply enable them to come to terms with the outcome in the case, but often matters to them as much and sometimes even more than the outcome in the case. So with those thoughts in mind, how does the picture look like in terms of youth's presence in child welfare proceedings? A survey was done in 2006, the first time we tried to determine around the nation what the picture looked like. How did youth perceive their presence in court? Was it happening? How did they feel about it? How did adults feel? Not simply lawyers and judges, but also child welfare professionals, social workers. How did they feel about this issue? And what we found in doing that survey is, interestingly, there was a tremendous divergence in the perspectives of foster youth on the one hand, as reflected in the purple bars, versus the adult child welfare professionals on the other hand, as reflected in the tan bars, as to whether youth were or weren't participating in court. Adults were much more likely to perceive youth as being there, and youth were much more likely to report that in fact they weren't in court. In fact, youth reported that over a quarter of the youth reported that they never were present in court proceedings. And this is a scan that was done of all states' youth around the country. Adults were more likely to see youth as being present in court, but still, even as to adults, very few reported that youth were there all or most of the time. Child welfare professionals, lawyers, judges, social workers, looked at factors including the age of the youth, the maturity of the youth, in assessing whether it was appropriate to include youth in the court process. And in being asked about not whether youth were in court, but whether youth should be in court, around a quarter of them, only around a quarter of them, believed that youth, slightly over a quarter, the 28%, believed that youth should be there most of the time. So by and large, the view of our adult professionals is that the presence of youth in court should still be the exception rather than the rule. And I think over the last 3 years, probably that 59% bar has come down, that more adults are starting to join the perspective that youth should be in court as a presumption as opposed to an exception. Not surprisingly, the view differed somewhat as to teens. Adults viewed teens as more appropriate to include in the court and the legal process, but even there, under 30%, around 29%, reported that teens coming to court was the norm. And interestingly, under 10%, 9% of the adults believed that a child's desire and a teen's desire to be present is something that should matter in the process. The more experience the adult professional had, the more likely they were to accept the view that youth should come to court. In contrast, youth felt that they needed to be there. They expressed strong views about their desire to be present and strong views about the impact it had on them when they were left in the dark. Many of them in states where youth are given a right to attend court reported not knowing that they had a right to be present, and many of them reported that they had no idea when their case was being heard in court, no idea what was going on in the court process. Nearly half of them, interestingly, identified their entire experience in care as likely to have been different if they had been there and been part of the process. So what does the legal landscape look like? We sort of know now a little bit what the attitudinal landscape looks like. What we know is that now we've reached a point, and this has changed greatly over the last 10 years, But we've now reached a point where the majority of states, with that number building, in fact, if the current legislation being heard today passes in Georgia, your state will be added to this picture. The majority of states consider children to be parties. The majority of states, around 33, give children notice of their hearings. They create a right to be present, slightly lower. 32 states give children the right to attend hearings. Many of them carve out, as does your bill that's pending here in Georgia, an exception that while there's a presumptive right to be present, if it's not in the child's best interest to be there for all or part of a hearing, that there shouldn't be an absolute mandate that the child be there, even if it's not in their best interest to hear certain particularly sensitive aspects of a hearing. And some state variations look at either an age line of demarcation, children above age X should be present and below age X should not, or some of them tie the right to be present to the kind of hearing. If it's certain critical moments in the case, some states are more likely to create a right for a child to be present than more mundane, although some youth will say nothing's mundane in their case, but more mundane review hearings are often less likely to be included in the right to be present. Couple examples of statutes. I always have to throw California up there. California, interestingly, has been legislating in this area. A few years back, it created a right to youth to be present, but every year it's added to that right, to the point now where there's a right to be present, a right to notice, party status, and most recently, an additional mandate that if the child is missing from the courtroom, the judge is required to conduct an inquiry as to why the child's not there, what notice they received, and there's a mandated continuance of the hearing unless there's good cause for the child's absence from court. Idaho is an example of a state with an age demarcation. In Idaho, age 8 is used as the line of demarcation for a right to be present. And Idaho, interestingly, creates a right not simply to allocute for the child in person to make their views known and be heard, but also a right alternatively to give written input. Many youth talk about the fact that they really wouldn't want, with mom or dad or others in the courtroom, to have to verbally express their views, but that being able to allocute to tell the judge how they're feeling in written form would be a much more comfortable way to do it. How does the Georgia picture look like? In part, I'm not entirely sure. I got differing views on Georgia law. Your statute, and some of you laugh because maybe some of you have differing views. The statute appears to define children as a party, but I think that there are some views that that's not entirely clear, although I did see at least one case that acknowledged the view that children were a party. There appears to be a notice requirement to children if they're over age 18, again, sort of one of those age lines of demarcation. It's my understanding that whether there are counsel for children in the state depends on where you are in the state, and the role of counsel for children varies in different parts of the state. Your pending bill, SB 292, at least in the form that it's being heard today, would make clear that children are parties. It would give them a right to be present, with that carve out that the court can decide to exclude the child from part of the hearing if it's not in the best interest of the child to be there throughout. And it provides a right to counsel, defining the lawyer's role to function in the quote-unquote traditional attorney-client role. How about federal law? There have been a few overlays on this issue added recently in federal law. In recent years, 2006, an amendment to the Promoting Safe and Stable Family Act added the requirement that youth be, quote-unquote, consulted in a, quote-unquote, age-appropriate way in regard to permanency and transition planning. That was based on a federal acknowledgement of the importance of youth's voice in planning for their own future. What does consult mean? Not entirely clear, and guidance that's been issued doesn't fully answer the question of whether you have to be physically present in court to be consulted. One New York case found, yes, you do. that a youth, at least in the eyes of the Pedro M. case out of New York, that a youth can't adequately be consulted in this process unless they're physically present in court. I think that's a little bit of an overboard reading. I don't think most other states would agree that consulting means physical presence in court. I think we also have to look at the recent Fostering Connections to Success Act. And for those of you who will be joining me tomorrow in one of my clinic presentations, I'm going to talk a lot more about fostering connections because it's really landmark federal legislation that has changed quite a bit the picture in terms of opportunities to support older youth and youth in transition. While it does create new opportunities and new federal money for the first time for states to be able to extend foster care to age 21, it also has some requirements in terms of youth involvement in case planning, saying that youth need to be part of that process and that the plan that's devised is one where the youth needs to be very much in the driver's seat, that plan should be as detailed as the youth desires and should cover a host of delineated areas, including any other that the youth may want to identify as their case plan needing to cover. I think on a more subtle level, we also have to acknowledge that in those states that start to move forward on fostering connections, extension of care beyond 18, that we're going to see some significant differences in a child welfare system and a child welfare court process that will now be supporting young adults. And that if we have 19, 20, and 21-year-olds under our child welfare jurisdiction, under our court supervision, that how we attend to the needs of those young adults and involving a young adult in the process needs to be looked at much more carefully than we might have looked at it already in terms of attending to the needs of children.
Question.
Yes? I'm sorry, we're just going to get a mic to you, and it's not because I can't hear you. I mean, despite age, it's just to make sure you're recorded.
With regards to the Fostering Connections Act and the involvement of the court beyond age 18, you know, how do they foresee that being implemented where now the case is closed when the child is 18, even if the child signs back into care? So how do they intend to implement that part?
Right. First of all, let me just, excellent question, and I will probably talk more about this in some remarks tomorrow, but just to make sure, did everyone hear that question? Okay. So fostering connections to success doesn't specifically answer what do we mean by extension of federal money to support youth beyond age 18. And it's my understanding that here in Georgia, and please correct me if I'm wrong on this, that some youth do receive support beyond 18, but it may be through a closed case, that the court case would actually be closed. To be able to avail yourself of the federal money, and realize it does require a state investment. Federal money is only 50 cents of the dollar. The state or local government, if a child welfare system in some states is locally funded as well, has to put the other 50 cents on the table. So some states simply won't choose to seize this opportunity because they don't have the 50 cents for every 50 cents to be matched by the federal government. If you do want to tap the federal funding stream, you have to abide by all of the other federal requirements that go along with Title 40 money, which includes court hearings, the 6 months hearings and reviews. So it doesn't mean a state can't continue to support youth beyond 18, but they're not going to get Fostering Connections federal money to do it. If they want to get the federal money that's now being put on the table for the first time to support youth beyond 18, they're going to have to abide by all of the federal requirements, which include that court supervision, that case review. Some people have asked, and there is a very lengthy, frequently asked questions on the older youth provisions of Fostering Connections on the ABA website, the ABA Youth at Risk Center for Children and the Law website. Some people have asked, if there has to be court supervision, does there also have to be an ongoing open child welfare case? That's a little murkier. And I think most of us who have looked at it have concluded we really can't move forward with every other engine running without a child welfare case and child welfare supervision remaining open. I don't know whether some states will look to have simply court supervision but no open child welfare case. And let me add one last thing, and then we'll go back to you. The other open question around fostering connections is, what do you do with the youth who at 18, in those states that are going to give youth, and a number of states are doing this, are going to give youth the right to say, I do or don't want to keep going? Because many states have said that youth should have some say in terms of whether they want to remain under jurisdiction of the court of child welfare beyond 18. We shouldn't force an 18-and-a-half-year-old kicking and screaming to be supported and parented by all of us. What do you do if the youth at 18 opts out and we close everything down? And then at 18 and a half, now that they're homeless, now that they're living on the street, now that the world is collapsing around them, they want to come back. They realize it was the wrong call to make. It's not clear. Fostering Connections didn't answer this right of reentry. I think our hope is that there would be some mechanism for reentry, but the states that probably are most FORI compliant in trying to create that right of reentry are doing it through sort of a temporary or transitional closure of the case, but leaving an open file so that youth can come back in if they feel a need for reentering. Probably more than you needed to know, but yes, follow-up question.
The other part of that question was, and if, again, as part of the fostering connections, if they're going to extend that monitoring, is that also going to extend the child's right to an attorney, because we're talking about proceedings that are still going through court?
Right. And everybody, I take it, heard the question again. So a couple responses to that. First of all, realize there is no federal right to legal counsel. Some states have already created a right to legal counsel. My understanding is Georgia doesn't have a statutory right, but SB 292 would create a right to counsel. The Child Abuse Prevention and Treatment Act, CAPTA, says that a child needs to have somebody there in court, a lawyer or a guardian ad litem, so it doesn't have to be someone with legal training. We are trying to get CAPTA amended through its reauthorization process to make clear that the definition of child in CAPTA includes individuals beyond the age of 18, because it seems a little odd for FORI money to flow under Fostering Connections, but there to be no CAPTA protections and rights. So I think, again, that's currently an unanswered question. There's no federal mandate for a lawyer, but does the CAPTA requirement that a child have somebody there on their behalf extend for those youth beyond 18 who are going to stay in the system? I think the better response, the more reasonable response is it sure makes sense that it does, but I don't think CAPTA is completely clear because CAPTA wasn't amended at the same time Fostering Connections has come in. So unless any other questions, and again, I will be speaking to two groups tomorrow. I'm going to talk a lot more about Fostering Connections because I know it's an exciting new federal law and lots of good questions around it. Let me just throw in one word on international law. There is a view on this issue in the international community. The UN Convention on the Rights of the Child, in addition to a lot of other really phenomenal things that it says, does opine on this issue and says a child shall be provided the opportunity to be heard in any hearing affecting the child. So the international community has embraced the view that children need to be heard in proceedings that involve them, affect them. Our country has not ratified the UN Convention on the Rights of the Child. We stand alone in the company only of Somalia in failing to ratify the UN Convention. Somalia does not have a functioning government right now, so I think they've got a good excuse. I expect that there will be efforts with our new administration to get the UN Convention ratified. So what are some of the perspectives before we move and transition into our ethics issues? How do people feel about the issue of youth in court? Many talk about the benefits that flow, benefits both to the youth, giving them a sense of empowerment, an ability to see and understand who that person is that's making decisions that are going to impact their life, an ability in a very otherwise chaotic and unstable life to seize some feeling of control over what's happening to them. Others talk about the benefits to judges, that there's a flow of information that a judge gets that they don't get from a paper file. They can see whether a child has lost weight or gained weight. They can see whether they seem drowsy or over-medicated. They can see whether they seem too hyped up, whether they seem happy or unusually sad. They can stay focused on the child. It can become a more child-centric hearing. When a youth is there, people feel compelled to engage them, which can often be a very good thing because you can hear about well-being issues that might otherwise never surface if you're simply talking about what are we going to do with permanency planning, where should the child be placed. Others talk about the incredible relationship that they will forge with the judge or perhaps even with their own lawyer by being there part of the court process. There are some youth who say that the one anchor in their life as everything else around them was spinning was the judge, that that was the person that inspired them and kept them on course. Youth talk about all of these benefits, but there's also a very heartfelt view in terms of the concerns associated with youth coming to court. Court can be emotional. It can be a place where we talk about things that we don't always want the youth to hear or be exposed to. It can be tedious and inconvenient for youth to come to court. Youth who already are missing too much school can miss a full day of school by coming to court and waiting for a hearing to start. So clearly there are perspectives that bookend both sides of this issue. Before we move into some of the ethics issues, I did want to have a chance just to hear some of the experiences you all have had. And maybe just starting by show of hands, how many of you routinely have cases where youth are in court? Just show of hands. Okay. And how many of you routinely have cases where youth are not in court? Okay. Hopefully you didn't raise your, okay, some of you raised both. So, and so let me actually ask, how many of you, it's just sort of case by case? Sometimes it happens and sometimes it doesn't. Okay, so I'm sensing that that's kind of, okay, more often than not. So let me just, for those of you who have sort of straddled both sides of this, maybe as we're passing the mic, just get some thoughts on it. Have you found it useful? Have you found it difficult? Have you found it harmful? Or is it something sort of case by case? Yes, why don't we start in the back and then we'll see if others want to chime in.
I am fresh off of a hearing yesterday in which I was representing 5 children in a TPR hearing, and the kids have been in care for 3 years, and they come to court for most of the hearings. And they testified during the TPR hearing was a physical, they came into care because of physical abuse. Their ages now range from 9 to 14. The attorney for defects was concerned about the children testifying, you know, especially in front of their parent,
Right.
you know, about the physical abuse. But I have been working with those kids for 3 years. They wanted to have some input. 3 of the children made the decision to testify in the presence of the parent, and 2 of the children, you know, asked for in camera. But all of them had a role in the hearing, and they felt very good about their input. But more significantly for me was that this was a hearing in which the mother had done the case plan and done all this stuff, and so she was saying it was a physical abuse. She learned her lesson. But the children came in, and the children talked about their experience and how even now. And so if those children had not been present, you know, and if the judge had not seen the, you know, the impression that they made, the outcome would have been, you know, different.
Yeah.
I think it's very important, especially sometimes too, for children to be in court, because sometimes they think that the reason that they're not with their parents are because defects has destroyed, you know, defects came in and took me from my mom, you know, for no reason. And at a certain point, and at a certain point, I think it's important for them to and this depends on their age, deal with the reality of why they are in defects custody so they can move on. And towards that end, I had an example of a teenager who came into care. And her mom kept saying, I'm going to get you back, I'm going to get you back. She was telling the teenager that, but she was telling defects, I don't want the kid back. And so the child was having resentment against the case manager, resentment against the foster parent because she felt all these people were taking her from her mother, and
Right.
she was experiencing emotional, stuff. So we sat down and talked with her, and I said, you need to hear this from your mother's mouth. You need to be present. And she heard her mother finally admit that it was she that was saying, I don't want the child back. And at that point, she literally the child did a 180-degree behavioral change.
Right.
And she was able to let go and move on.
Thank you. I mean, that you hit on such a rich number of tremendous issues. And actually, we are going to come to the in-camera issue. I think that's a very interesting one and really raises some ethical concerns for judges. So I'm thrilled that you mentioned that. But I think a lot of the issues that you raised, sort of that burning desire of youth to want to have their say, and just that feeling if they're not there for the reality check. I mean, part of them may blame the department. Who else do children often blame? Themselves. I mean, it's not uncommon if a child doesn't go home and they've not been there to hear, why am I not going home, to think, what did I do wrong that I can't go back to mom, or can't go back to my siblings and be together with my siblings, or can't be back in my community. So I think a lot of youth talk about the fact that they live with a lifetime of guilt if they weren't there to hear, what was happening and why did it happen. And I think the other point you make so well is the tremendous impact a youth saying what lawyers otherwise might say will have on the court. I mean, nobody is going to say it better or more passionately than the youth themselves if they have sort of that courage to do it. And obviously, the children in your case were probably very fortunate to have had you to work with them for a period of time and establish a relationship that empowered them to be able to go into court and do that. Other thoughts or perspectives? Yes, in the back, and then we'll sort of move around.
Hi, I'm a child advocate attorney. The issue that I struggle with, and I'd like to get your thoughts on it, is unfortunately a lot of our clients aren't doing well in school, or they come into care because there's already educational neglect, or they already have too many unexcused absences, or there's a truancy issue. And when they tell me they want to come to court, my first reaction is, okay, let me go ahead and draft an issue in service of subpoena. And then you start to think about it more, and you're like, oh, do you really need to miss school? Because in all likelihood, it'll be reset anyway. Or you get a judge that says, why is this child here? They're missing school. So that's the struggle that I think a lot of us in my office have.
I think that is a very valid struggle that we should be having. I mean, if we're not thinking about it, then we're not responsibly, sort of looking at the full landscape of the issues of what's important in our clients' lives. I think especially for teenagers, you've got to be thinking at all times what's going on in school. I have a few thoughts on that. I mean, unfortunately, in Los Angeles, where I come from, the practice is you bring all the kids in, you transport them in the morning, and they sit around all day. And then their case gets heard. And then they go back, even if they were heard at 9 a.m. on the morning calendar call, they don't go back until the vans transport everyone back at the end of the day. Now, we have an amazing courthouse facility to make it very pleasant to spend the day there, but my view is let's spend less money on the facility and put more resources into getting them back to their real life rather than a field trip for the day to school. I think we need to be a little bit more imaginative at times around, and I realize this is more sort of a wish list, and then I'll tell you more kind of the practical advice on it. I think we need to be more imaginative around when we set hearings. Why shouldn't hearings, especially for teenagers, be in the late afternoon after court hours? Now, I know the why is because the judges will never do that, but and there are no judges in the room, so we can pick on them for the next couple of hours. But I mean, I think we should be raising that issue. Why can't we have New York now does a teen court where they have an afternoon setting? A lot of courts in tough budget times went into night court. I'm not suggesting that we want to bring kids in, in late hours of the night, but maybe after school hours. Certainly, time certain hearings would make things a lot easier. I know, some courts have moved to that. I worry not simply about the youth who spend the day there, but the parents who are struggling, who have umpteen different requirements that we put on them. And then we bring them to court to sit around and miss work for a day, every few months. Sometimes their case doesn't even get heard and they have to come back the next day and miss another day of work. So, I think if we could do time set hearings after work hours, after school hour hearings, it would benefit everyone. Practical advice, since those are more kind of the pipe dream, we have a calendar in my old office that we would use. We would know when finals week were in our major school districts, when the standardized testing was, although some schools, interestingly, prefer foster youth not to be in school when they do their testing because they think their testing scores will be higher. So we actually found some school districts that would encourage the foster youth to stay home that day, which is more offensive than you even want to talk about. But we would ask courts, if you're setting a hearing months out, please don't set it that date. Your Honor, my child, is in high school and they have finals week that week. Spring break is the next week. Could you set it the following week? So I think if we paid attention a little more to the school schedule, that maybe it would help a bit. But I think at bottom, it's part of that case by case. If your client wants to be there, I think you need to thoroughly discuss, the pros and cons. And obviously, missing school is one of the cons. But, at bottom, an informed decision is better than no decision in my mind. Other thoughts?
Can I give you one more?
Yes.
This case involved a private case I had on Monday, which was a guardianship case. It had started out as defects, but it ended up with the mother giving guardianship of the child to her sister, the aunt. And then the mother filed a petition to terminate guardianship. So a hearing was set for Monday. Just got the case a little over a week ago. I went out to see the aunt, found out that the child, after having a conversation with her mother, went upstairs and cut herself. The hearing was set for Monday. The child wanted to come to the hearing. I had not had an opportunity to get her medical records, to talk to her therapist, to get any information. And I was very alarmed, by this act. And so when it came time for the hearing, I asked the child to remain outside of the courtroom because I was going to ask for a continuance of the hearing, and I had to give my reasons to the judge. And I was concerned about stirring up whatever, psychological stuff was going on with this girl that caused her to, cut herself previously. That was an instance in which, I kind of arbitrarily made the decision that the child should not be present in the courtroom at that, time. I want to talk to her therapist to see what the therapist thinks about her being in the courtroom when these kinds of issues are being discussed.
Yes. Hold on one sec, because she's just going to get you the mic to. Yeah. And again, it's not that we know we can't hear each other, but our recording won't pick up. Yeah.
Sorry, I just want to, before you answer that, want to know, are you appointed as an attorney for the child? Like, is she your client, or are you a guardian ad litem and you're responsible for her best interests?
So, excellent question. What is the role? But we're going to build that into our first ethical hypothetical. No, I mean, your comments are wonderful, and they're actually laying the groundwork. I'm not planting, the wonderful woman in the back or the comment up here. I mean, you are actually wonderfully laying the groundwork for some of the ethical issues we're going to be discussing, because these questions are going to be woven into those. Let me just sort of, to wrap up this piece of it, I do want to share sort of the good news, which is when we bring youth to court, they do report that they really feel listened to, which, again, as a parent of a teenager, surprises me, frankly. I never feel like my kids feel like I listen to them. Well, or I like to hope they think I listen to them, but at least from what they say, they don't suggest that they feel I'm hearing them. It's sort of the "you don't get it, Mom." It comes up often enough that I presume they don't feel that I'm listening. But we do know with youth that when we bring them in and let them weigh in, that fewer than 10% feel that we've ignored what they were trying to tell us. Probably even a lower figure than lawyers would report. I mean, how many lawyers would say we never, how many lawyers, feel ignored? So now I think we'd like to turn to some of these ethical issues that many of your comments raised. And as I said earlier, in lecturing on this issue around the country, we found things like in-camera hearings, what's the role of the lawyer, just a whole host of these questions kept coming up in the dialogue, and that we really couldn't do this issue justice without having an ethics overlay to the discussion. So we want to now turn to some hypotheticals. Some of these may start to sound a little familiar given the conversation we've already started. So, scenario number one. We have Jamie, 11 years old. Jamie really wants to come to court, kind of akin to, it sounds like a couple of the clients in your five-sibling case. Jamie has a review hearing coming up, and the social worker has pointed out that there's going to be discussion about Jamie's mom's recent arrest for prostitution, and really doesn't think that Jamie should be in court to hear about that. So, you're Jamie's lawyer. What do you do? Any thoughts? Yes, do you want to? Okay, so sorry, and I apologize for the aerobics you're doing with the mic, but you'll get your workout today. The fact that it took you a few minutes to get it to her means she could finish chewing the sandwich.
I know.
So.
Well, the first thing I would do would be to look at the history of the family. But something, I can't remember where I was. I was at a seminar somewhere, and one of the speakers said something that changed the way I looked at these cases. And the speaker said that so many times we want to protect the children from the very families and the histories that they lived. So you're really not protecting these children. If anyone is completely coherent and cognizant of abuse, it's these children, and you really aren't re-traumatizing them. It's actually therapeutic for them to have a voice. So having said that, I still think there is an analysis that has to be done based on the age of the child. If this was so again, it goes to the history. If this is and the particular context, if this is a very parentified child that was well aware of what mom was doing and was going, as some of our clients are, was going to work with mom as she prostituted and was in another room, then I don't think that I would necessarily oppose my client being present, but like someone else said in the back, you do want to speak to your client about it.
All right, and I did hear that. Who said talk to Jamie? Okay, well, you're closest to the mic, so to avoid her. And I want to come back to your excellent points in just a minute. I want to hear first, so I'm Jamie, we're talking. What do you want to ask me? What do you want to talk about?
Sit on my hand next time. I was that you're asking who would agree. No, I think I would, I think you should know, like Fatima said going in, how much Jamie knows, and that would certainly make a big difference as to how you talked about it. But I mean, I think with my client, I would say this is going to be a pretty rough hearing. There are going to be a lot of things said about your mom, which may be difficult for you to hear, and she may be emotional. Now, are you, let's talk about whether you're prepared this hearing to hear all that, or maybe you'd like to wait for the next time and then just kind of, at least lay it out there and see how they react to it or respond.
So I think I heard a little bit of talk to Jamie and also sort of advise and fulfill your role of, sort of telling her, here are some pros, here are some cons. You want to know what Jamie knows. Does Jamie, was Jamie out kind of walking the streets with mom, or is this going to be a real shock to Jamie? Gee, I thought Mom, went to the grocery store every night for a long time. I don't really have any sense. And what if Jamie says, well, what do you think? You're my lawyer. Flip a coin? Yeah. And this may well come back to your question. Does it matter what your role is as Jamie's lawyer?
That definitely would play into it, and I'm not practicing right now, so I have no personal experience, but
Oh, then you have all the more reason to opine.
I was thinking, my first thought, before even thinking back to my earlier question, was that I would wonder if just if there was a possibility of just excluding Jamie from a certain portion of the hearing as opposed to excluding him from the complete hearing itself and not appearing at all. And if we, from all other analysis, decided that Jamie shouldn't hear about his mother's recent arrest, that might be able to be arranged with the judge in advance to discuss that and then bring Jamie in, or send him out at an applicable time, and that might be actually discussed with Jamie too. There's some things that we need to discuss with just your mom, and we're going to, you'll be needing to leave for just a second and we'll call you back in or something. So that's different from my thought about the guardian ad litem versus the child attorney position, though I have a different thought.
Okay, so I want to pause, and then I'm going to get your view on that issue. Paula, what else should we be thinking about or worrying about?
Well, we should remember that we are lawyers, and there's nothing wrong with lawyers serving that counselor role. I think a lot of times when you're talking about children, it's awkward for us because lawyers could probably fairly easily talk children into doing almost anything that the lawyer wants the child to do. So you've got to put on a couple of different hats and figure out in a situation like this, if it is a child who you believe should not be present at the hearing, you may be able to convince the child that he doesn't really want to go to the hearing. I think the first question that I would ask in talking with Jamie is, why? Why do you think you want to go to court? I think explaining about how difficult this hearing might be and how hard it might be for him to hear some of the things that are said about his mother is great on the counselor role. But if he can articulate some reasons, some things that he thinks he wants to know, or some real reasons that he wants to be there, it may be that you, with your counselor hat on, can convince him that he doesn't have to be there for those things to happen. If he really just wants to be there so that he understands what did happen, what's said about him, what's going to happen to him as a result, then surely in your role as counselor and communicator for the client, you can at least convey to him that you've got an obligation to let him know what happened, that you aren't going to let him get treated differently or sent away somewhere without understanding why that is, and assure him that you will do what you can to make him understand what happened, that he doesn't have to be there to see it for himself. The other thing in all of this, though, is that our rules require communication. And it's Rule 1.4 of the Georgia Rules of Professional Conduct and the Model Rules of Professional Conduct. What they require is that you explain things to a client in a way that the client can understand, which obviously when you're talking about a child means that you speak differently from the way that you talk when you're talking to a judge or another lawyer. You simplify your language, adapt what you say, create analogies. Anytime I'm representing a child, I find that what they know the most about is television shows for some reason. And
hard to guess why.
Yeah, and if you can compare what's going to happen to something in a movie or a TV show, they're more likely to get it. And trying to make children understand the role of a lawyer, they can do that now because there's so many lawyer shows on television. So that's the kind of thing, and you all are professionals. Every time I talk about representing children, every other time I've talked about representing children, I'm talking to groups of volunteers who do other things, typically with their lawyer time, but who take volunteer cases where they will be representing children. And so I spend a lot of time talking with those groups about how they might adapt their communication and different things that they might try to get through to a child, to develop a rapport with the child, and to make sure that the child understands what to expect within the context of the case that the lawyer has. You all do this, it sounds like, all day, every day, so I'm really not going to talk. Hopefully you figured this part of it out by now and you understand the communication role, but I think the part to emphasize right now is that lawyers are also counselors. And with children, as with any other client, one of the obligations that we have is to give the client the benefit of our legal training, our experience with whatever it is that they're involved in, to advise them what we think they ought to do. And there's nothing wrong with that. You know, there's a line sometimes where you're trying to talk a client into doing something that you think is in the client's best interest. You know, you really need to take this settlement offer, and where you become a bully in trying to get the client to do what you want to do. So don't cross that line. But there is no problem with counseling this child that it's not in his interest to attend this hearing, that you will provide him with the information that he needs, that you'll meet whatever his goal is, whatever his reason is for being there, without him being there if you think he's too young to be there. Yeah.
Question in the back, and then we'll come to the middle.
I was just going to say it's not as much a question, but
Okay,
I found you were saying about trying to get a kid to do what, or to try to talk someone into. I find with kids, at least if you have a good rapport with them, I used to be a child advocate attorney, that they will do whatever you, like they're looking for you to tell them because they trust you and they just,
And
so
they
I
want your approval.
yeah,
often.
absolutely. And you were saying about asking them why to go or why not to go and talking to them about school and then helping, because it's really hard because they pretty much are just like, well, what should I do? And I thought the way you said about asking them and getting them to talk to you about why they would, or because I found for me, it came down to me really, having to talk to them to find which way is best, because they're going to do whatever I say in the end. Does that make sense? And so it's really hard to see what they wanted.
That's been my experience. I've only ever done truancy type hearings, and you really do find that children want to please adults. I mean, they really are children as a bottom line. And if you have a rapport with them, I do think with the counselor hat on, you can sort of help them reach a decision that's in their best interest.
And I think I kind of want to connect that to one of the comments that was made earlier, which is I do think you need to probe. If your client immediately says, well, what do you think I should do? I mean, how many times is that one of the first things that any client, adult or child, will say? You're the lawyer, you're the expert, what do you think I should do? I mean, it's kind of, we go to the doctor and the doctor says, here are 2 treatment options. Well, what do you think I should do? If I were your spouse, what would you advise me to do? But I think before you rush in to answer that, because as Paula said, you do have a duty to advise, but you also need to probe a little bit. What you think the client should do really is going to depend on why they want to be there, what their need is to hear. And I think too often we rush to assume, whether it's information about moms prostituting or simply people are going to be talking about the abuse Jamie suffered. How painful is that going to be for Jamie to hear? Well, a lot of youth are the first to say to us, you know what, I lived through that pain. If you shield me from hearing it, you're not shielding me from what I've already lived through. I've lived through a lot worse than sitting in a courtroom and hearing that. I need therapeutically to not be looking backward, but to have the ability to heal and look forward. So going to court really can be a positive therapeutic experience. And I think in presenting the options and counseling Jamie, we have to kind of bear that in mind, and bear in mind that just as there's a pain and a cost associated with being in court, there is a cost and a hurt and a pain associated with not being in court. And we need to better understand what's going on in Jamie's mind before we really start to try to counsel Jamie about which the right route is to follow. Question or comment in the middle with the gray?
And also along the same lines of the counseling question, and I think one of you mentioned it while you were presenting, the question of, sometimes if it's a child and a lawyer speaking to a child, even if you're meaning to give advice in a way that's simply counseling to make them aware of the trade-offs, whatever they kind of hear, what they think you're saying, they're just going to say, okay. Like I find that, I'm still new in dealing with child clients, and I often find that even if I think I'm phrasing it in a way that's not trying to sound overbearing, that they're saying, okay, kind of like trying to just adhere to what they think you want as an adult, or what they think you told them to do as an adult. And I'm just curious if people have perspectives on smart ways to counsel, but in a non-threatening way that empowers the child to say what they want.
Right, and maybe what I'm hearing you say is both in a non-threatening way and maybe also in sort of a non-judgmental way, because how we communicate the options. I mean, if we say to Jamie, look, you can come to court, you'll miss school, you'll sit around, it could be boring, it could be really difficult. Or you don't have to come to court, but that's your choice.
Basically just made the choice for them.
You
yeah.
absolutely did. And frankly, even if you don't load the deck that way, with children, tone of voice, mannerisms, I mean, there are a whole host of nonverbal cues that we can give Jamie. So I think some of it is how do you do it in a way that you're not threatening or overwhelming Jamie, and how do you do it in a way Jamie can understand? I mean, as Paula said, communication is the key, and the rule talks about, explaining things in a manner and to the extent reasonably necessary to let the client make the informed decision. So that doesn't mean we stay completely neutral or agnostic, but it does mean that we provide information to Jamie. So how do you best do that? Do you have any thoughts on that?
No.
Okay.
I think whoever had said to talk to them ahead of time and find out what they know, but I think that it is also really, really important that a child has follow-up after that hearing, because sometimes they will be told, what do you want to do, or what would you like to see happen, and they may say it, and they may think it's going to happen, and a lot of times it doesn't happen, and that piece is never communicated to them as to this is not your fault because you weren't there, because you were there, and this happened, and so much of that, being a DFACS worker, you sometimes are running from one thing to another, and when the hearing is over, you're done and you're on to another hearing, and you've still got this kid with all his emotions of seeing whoever he saw at court, and just that follow-up. And sometimes I think the outside people, like the attorneys, are even better than DFACS, because so much, they don't associate the negativity sometimes with that, and just that follow-up I think would be helpful.
And I think that's an excellent point. I mean, communication shouldn't simply be before. Frankly, it should be before, during, and after. I mean, if your child is there in court, they're not a wooden statue. I mean, they're sitting there and they're probably overwhelmed by what's going on. And I think you have a communication obligation as the hearing's unfolding. To also try to make sure that we're not talking in legal lingo or statutory numbers. I've heard a number of times from kids who have come from court, gee, I was in, I was out, and nobody ever called or talked about my case. Minor's case got heard, but, when did my case get heard? Well, they never heard their case being discussed because nobody interacted with them. They just kept hearing somebody called minor being talked about. So, and there's also the after communication. I mean, what's the most common question any client, child or adult, asks after a hearing's over? They leave the courtroom. What did they look at you and say? What just happened? What just happened? I often leave the doctor's office and say to my husband, what just happened? But, court is very difficult to understand. And I think there's that, as you said, there's that tendency to just move on to the next case. And you really have an obligation when the client is most vulnerable, or even the next day, to do a bit of that debrief. Now, hopefully caseloads are such that they enable you to do that. But the other thing I would encourage children's attorneys to do is to also think about who else is going to be interfacing with the child later that night. I mean, if they're going home to their foster family or some other residential placement, and they had a really emotional hearing in court, shouldn't you perhaps give somebody the heads up, not divulge client confidences, but if they had a really tough day at court, maybe you want to call the caregiver and say, Jamie may come home upset, and that's okay. This was a difficult court hearing, but I just want you to be aware of that so that they don't get a timeout for coming home and getting into a fight with another kid or acting out. So I think that after debrief also perhaps extends to significant people in Jamie's life. I do want to come to your question about what about the role of Jamie's lawyer? How does this equation, this calculus differ if Jamie's lawyer is a traditional client-driven lawyer versus a GAL more best interest model? So you asked the question. I'm going to put you on the spot and see if you've got some thoughts.
I'm thinking that when you're thinking about it in the best interest of the child, the guardian position, that you're doing more of the analysis of, whether you think the child is old enough, whether in your experience it'll be beneficial, the school issue, whether school is most important that day, or court, or whether you think they'll even hear the case or not. All of that, I'm thinking you weigh all the outside factors of the child's life more than to make that decision than when you're the child's attorney and their opinion and their decision is your focus, and you're advocating for that child's specific position. If they're saying they want to come to court, then I think they'd better be in court. I mean, that's what they're saying, and I wouldn't try to alter that, I think.
So I do think that role is going to have to, just as you identified, play into the equation. You know, what hat do you have? Paula, do you have thoughts on that?
Yeah, I don't think, are any of you all appointed in a dual kind of a role where you're serving as both guardian ad litem and lawyer for a child? Okay, I know that we do that for truancy cases, the ones that I volunteer with, but I didn't know that that happened in other kinds of cases in Georgia. I do think that there's some special concerns there because you are supposed to be both representing this person and doing what's in their best interest. And sometimes as a representative, as a pure lawyer with just that hat on, you inform the client about the client's options, you communicate in the way that Rule 1.4 requires, but ultimately the client makes a decision about how they want you to advocate, or at least the result for which they want you to advocate. And you as a lawyer do what you can to make what the client wants happen. Now, when you've got the GAL hat on, you're supposed to be reporting to the court and doing what's in the best interest, or advising the court about what you believe will be in the best interest of the child. Typically, it's a miracle to me, frankly, that we don't see conflicts more often with these dual appointments. But we don't, and I don't know, we don't see them very often, at least from the ethics hotline perspective. And I think, you know, as I look through this audience and see a whole bunch of my former legal aid friends and other folks who don't hesitate to call when they have a question or a problem, I feel like we'd be hearing about it if there were a bunch of conflicts in the dual role going on. But when there is, typically it's with something like abuse, where the child doesn't want the lawyer to say anything about it, or you know, in a truancy case where the child doesn't want the lawyer to say anything about it to the court, but as guardian ad litem, the court needs to know that this is going on. In situations like that, we've on occasion had to advise one of the volunteers to resign from their role as, wait a minute, which one can you resign from? You resign from your role as guardian and continue to work as lawyer, and that way you protect the confidences and secrets of the client. You can't be the one to reveal whatever the confidential or secret information is. The court appoints a new guardian, and hopefully that person will be able to, you know, develop enough information to advise the court in the way that they need to advise the court. So, you know, it can be tricky, and I think a lot of times lawyers who don't do this kind of work routinely are uncomfortable with that dual role, because in the guardian role you really are allowed to use your best judgment even where that's not what the client necessarily would direct you to do.
Yeah, hold on, sorry, one sec.
I'm sorry. Usually I'm too loud for English.
Yeah.
Paula, I have a question about this dual role business, because it's occurred to me, and you know, I used to do whatever role I could at one point, but it occurs to me that if you are in a dual role and you've determined that the child needs a guardian ad litem because what they want is not in their best interest, then you've pretty much compromised your ability to be a zealous advocate as well. I mean, in terms of being their attorney and doing what they want. You may parrot what they're saying, but do you really think, yeah, exactly. So don't you think in many ways to stay on as attorney, once you've determined that they're not thinking in their best interest or wanting what's in what you determined is in their best interest, that you should really withdraw from the entire case?
Under the rules, that really is a decision that you as the lawyer are allowed to make, and to use your best, you know, you're supposed to sort of take a step back and use your best judgment about it. But it's not something that typically anybody would, well, certainly my office wouldn't second guess you on, because that becomes a personal conflict. If you don't believe you can do the best job for the client because of your personal feelings about the matter, then ideally, yes, you should be allowed to step back and get out of the case. I know, though, with many of you and the resources of courts being what they are, that may not be an option. You know, a court might not even let you out if you tried to withdraw from the case. And so I really do think that if you just do the best you can, frankly, you're not going to run afoul of the rules of professional conduct, although, you know, in some sense, I guess that it's a shame for me to be sitting here even saying that. But that is a personal conflict where the rules allow you to use your judgment in determining when the conflict in your mind is so strong that you can't exercise independent professional judgment on behalf of the client in the way that you're supposed to under these rules.
Let me move to sort of a slightly different dimension on all of this that we've touched on a little bit, but I think it threads through many of the variances around the country and how this would be analyzed, which is just the question of who should be the decider on this. Who should decide what Jamie is going to hear, whether Jamie is going to be in court? Now, I mean, I think there are a couple of options. One is the legislature. They should just say always, never. But hopefully that's not where we end up, because I think even the states that recognize that Jamie should have a right to be there would carve out, if it's not in Jamie's best interest, to be in all or part. And I think the point was well made. This shouldn't be an only or never situation. It may be that we let Jamie come into court, but if something's getting really dicey, then we have Jamie absent him or herself from that part of the proceeding. So most legislatures put a little bit of flexibility into this, but then the question becomes, should it be Jamie's call? Should it be the lawyer's call? Or should it be the court's decision? So how many of you think it should be up to the court to decide at the end of the day whether Jamie should be there or not? Clearly no judges in the room, okay. Nobody would give the court the deciding vote. How many think it should be Jamie's call to make?
Let me say this.
Yeah.
Manager is saying, I don't think the child needs to be there, and you are his lawyer, and you're saying my child wants to be there, ultimately, it is going to be the judge who decides. You will still advocate your client's position, and the party that doesn't think is good for him to be there will be advocating their position. So, I mean, ultimately, the judge will make the decision.
Okay, so you're actually coming more in the camp of, I mean, some states won't let the judge make that call. Some states, and I'll show you a couple of these iterations, but I think, so we are hearing now a little bit of the let the judge make the call with lawyers doing, their advocacy work. I didn't throw out the option of the caseworker should make the call. Let me actually scroll into that one for a second. How many of you think it should be the caseworker's decision? Okay, nobody's going to go, all right, we have one.
Argument.
Okay.
That it should be the caseworker's decision.
Okay, and give us the argument.
We'll say DFACS, because DFACS stands in the role of the parent and makes the decision ultimately of what's in the child's best interest, supposedly.
Now, I thought the other argument that maybe I would hear, I mean, so that would be one element of it, that that they are the ones sort of filling that parental responsibility. Another argument might be they don't have as much of a dog in this race. Their client is sort of a little bit removed, so and I think that ties very closely to your best interest. They're simply about what's best for Jamie. So we have the caseworker, we have the court, and then I think we were just starting to get into how many of you would let it be Jamie's call? Yeah, thinking about it. How many of you would let the call be made by Jamie's lawyer? Okay, maybe. So what you sort of reflect are some of the state splits on this. Florida would let the court make the call with giving a little bit of guidance on what the court should look at, age, physical and mental condition, and those are pretty common sorts of factors that we see. Your proposed Georgia statute would let the court make the call by starting with a presumptive right for children to be present. So the legislature is weighing in there if the proposed statute passes. Namely, the legislature should say yes, is saying yes, children should be there, but the court can decide if it wouldn't be best for them to be there. Your proposed statute does not define factors. Most states don't, because I think they presume it's not that difficult to figure out what factors should matter. Virginia is a state where the lawyer would decide. The GAL decides whether the child should be present or not, looking at those similar kinds of factors, age, maturity, and another critical element that I think we have to bear in mind, which is what kind of hearing is this? Is this TPR, or is this, a more standard review hearing? And I think we've got to be considering, what kind of issues are going to be discussed in court. And then there are other states that leave the call up to the child to make an advised, consulted, informed decision, especially for teenagers.
Let me just throw in that I don't think that our rules of professional conduct in Georgia would fault any of those responses, frankly. I don't think that there is a wrong answer or an answer that would run afoul of the rules of professional conduct. Our rules typically require a lawyer to do as the client directs if the client is capable of making a decision in his best interest. And we're going to talk about client under a disability and how you proceed in those situations in a minute. But assuming that Jamie is capable of understanding and then making a decision that's got some rational basis to it, whether you agree with it or not, typically the rules would require that you do what he says if it is something that is substantive. I think on this, there's a good argument that could be made that it is more a matter of procedure or one of those things that's typically left up to the lawyer's discretion, like whether to give an extension of time to the other side for filing discovery or whether to oppose a request for continuance or something like that. Those are decisions that our rules allow a lawyer to make without consulting with the client, just using the lawyer's best judgment or sort of adapting whatever the customary courtesies are in the jurisdiction. I really think that you could say that this is one of those kinds of decisions. And so it isn't something necessarily, it's not the kind of decision necessarily where it's a do or die, I've got to do what my client told me to do, because I'm not sure that it is substantive. On the other hand, I could argue it the other way. Right. Depending on what kind of hearing it is and what his role would be if he were there.
And why Jamie wants to be there.
Why Jamie wants to be there. It might be substantive. So if it's a matter of him just getting his feelings hurt or hearing some unpleasant things, I don't think there's any problem at all with the lawyer substituting her judgment and saying, you can't go. And there are all those reasons that we've already talked about why that's not how you want to treat your client. But as a matter of the ethics issue, yes or no, I don't think there's a problem if that's what it is.
Right. And sort of that dividing line that Paula was referring to, I don't have a slide on it, but in the model rules, it's Rule 1.2 that sort of talks about that division of responsibility that gives the client the right in the first instance to set the objective. Sort of, I like to think if the client says, here's my finish line, here's where I want to go. And then the lawyer is the one who decides what are the means that are to be used to get there. It's almost like, kind of what route should we go through to best reach the finish line. So is this the finish line, more akin to the finish line, sort of the objective, or is it more akin to how are we going to best get to that objective? I think, you could argue either way. Yes?
I was just going to say, would it matter if you're considering the child a party? Because can you automatically exclude a party from a hearing without having some sort of a hearing to decide if the party could be part?
That becomes way more, maybe that becomes closer to it being a right that the child has if the child wants to execute it.
And I will add this. I mean, some have kind of asked, why does it matter if state statutes make children parties if we give them all these other rights? I mean, I think we always have to bear in mind there are the ethical rules, which is what Paula and I have been talking a little bit about most recently, but then there are also the statutory rights and there are procedural sort of due process rights. I think if the child by statute is a party, then it may not so much be an ethical issue, but I think that there are some procedural protections that parties should be provided with. And most of the states that make children parties, I mean, there are some notable exceptions, which I find to be odd. I think New York, for a time, it may not be anymore, was one of these states where children were parties, but they were given no rights to notice, no rights to be present, no rights to be heard. And I kind of looked at that and thought, boy, I'd love somebody to bring a due process challenge in New York and say, what do you mean I'm a party, but I get none of these other trappings of the procedural rights and protections that parties get. So I do think above and beyond the ethical issues, there are the procedural issues, there are the statutory rights that might be created in a given state. Let me switch a little bit now, the ethical quandaries, and add another layer. So you decide, or you and Jamie decide Jamie's not going to go to court. And you find out Jamie did not know that mom was out there turning tricks. And the court decides, not surprisingly, Jamie's not going home. You visit Jamie or call Jamie or debrief Jamie after the hearing, and Jamie says, but I really wanted to go home. Why aren't I going home? What do you say? Do you tell Jamie what the real reason was? You kept Jamie from court because you didn't want Jamie to hear this information. Now what do you do? How many of you are going to tell Jamie about what, the answer is? Mom, your mother's a prostitute, and that's why you're not going home. Okay, no, all right. I mean, look, I could have used even worse words, but, we're on tape here, so, yeah. I mean, all right.
Situation, it's almost like your situation with the, who was it she was in court with last week? Oh, no, you were talking about the teen who didn't know that her mother had been saying to everybody but her.
Right, I don't want you.
I don't want you. So.
All right, I mean, what if, let's turn it a little bit. I mean, whatever it was that came out in court, mom's a prostitute, or mom says, I don't want you back. Jamie asks you, why aren't I going home?
I'm assuming, this is a review, I'm assuming I've had Jamie for a while. And I can talk to Jamie, I know Jamie, I'm used to talking to Jamie at a level that he understands. And so I would tell him the reason that he wasn't going home. I wouldn't tell him that, I wouldn't say your mom's a prostitute. There are other ways that you can,
okay, so talk to
characterize
me.
so he gets the essence of it without calling his mom a streetwalker.
I'm Jamie. And I'm sorry, your name is?
Carla Friend.
Carla?
Uh-huh.
Oh, Carly? Okay. Carla, okay. Carla, what happened? I'm not going home. I really wanted to go home. Why aren't I going home?
Okay, and I know Jamie. Jamie, we were in court today, and there was some information that came to the court that your mom just got arrested again.
Why did she get arrested?
She got arrested because she was out, and the police picked her up.
What did they pick her up for?
Well,
I know she's an experienced lawyer, so she's going to be good with this. But what'd they pick her up for?
I'm going to say, your mom was out on the street. She needed some money, and she was trying to get some men to give her some money. And the police stopped her.
Wait, what do you mean she was trying to get men to give her money?
Well, you really want Jamie to be stupid.
Jamie knows what he's asking.
Yeah, come on, Jamie, come on.
All right, anybody want to help her out? Yes. Pass the mic down.
But isn't that the point? If Jamie is asking those questions, it's time to talk candidly.
Okay.
So
you're gonna tell Jamie.
I think that was her point. She knows Jamie. She's built a relationship with Jamie, and she's gonna, I think, as any competent lawyer who's dealing with children on a regular basis, gonna know how to get Jamie to understand what's really going on. And if this 11-year-old is sophisticated enough to digest what's going on, and that's where your questions are, you're playing Jamie, and you know what you want to know, and she's going to tell him what he's got, what's going to happen. And when all is said and done, children that are going through this kind of havoc, children who are, as my daughter, the juvenile judge, sometimes says, are damaged goods by the time she sees them. They're not naive, and you're not protecting them.
Pretty street smart.
By not being truthful. Your relationship as either guardian ad litem or lawyer, I would suggest, is ultimately with a kid 11 and old, our hypothetical Jamie and older kids, is ultimately, I think, going to be dependent on your ability to be really honest with that child, so they can deal with the reality of their very difficult life.
I think we had another comment there, and then we'll come up to the front. So, and I think before we get to that, obviously, I sense that if pushed enough, you were going to tell Jamie what was going on. And I think the issue of sort of what will it do to the relationship of trust otherwise? It's not simply, that ability to counsel if you don't have trust. you're not going to get information from Jamie if Jamie doesn't trust you. Jamie's probably going to close up. And then, your value to the court, to the system, to everybody else, if you don't have the kind of relationship to be able, to guide Jamie, gain Jamie's confidence, is going to suffer. But yet, and we'll come to the ethical overlay with Paula in a second, we know that the ethics rules don't say, go in there and spill the beans always. While the ethical rules do create generally a starting point that you shouldn't be withholding information from your client. And we're going to talk in a second after that about the client with diminished capacity. But before we come to that, we'll talk about this issue. But yes, thoughts?
I just also wanted to say that this could be an opportunity for education, to educate the child. What is prostitution? Let's imagine Jamie was an 11-year-old girl. She could be prostituting at 13 or 14.
Because she saw it modeled at home, perhaps.
Exactly.
May not know that there's a right and wrong on that.
Right, and so educate that having sex or participating in sexual activities for money or whatever, it's a law, and you can talk about the law and you can educate on that particular point of the law, and now you're educating the child so that they have a better understanding, so that they don't find themselves in the same situations, or if they're considering it, they understand some of the ramifications that when you have a child, if this is what you're doing, your child could be removed, or these are some of the consequences that follow this type of behavior. So I think it's a time for education as well, and that's just another area that should be looked at.
Excellent point. I mean, there may be a teaching moment in this, as they say, a broader education. While we're moving the mic to the front, Paula, tell us about some of the ethical rules that might factor in.
Well, I want to point out a difference in Georgia's rule and the comment here to Rule 1.4. Rule 1.4 is the one on communication. We've been talking about that. And as you see, it allows a lawyer to withhold or delay transmission of information when the information would be harmful to the client. And if you are dealing particularly with a client with diminished capacity like a child, I think you've got you get to use your judgment under this rule in not right away telling things that you think it might be harmful to the child to hear right away. Or, if the child is particularly distraught today at the end of the hearing, you can wait until tomorrow or later to reveal some of the information that they need to know. Now, this comment talks about
diminished.
Wait, there's a part that our rule doesn't. Oh, I'm talking about.
Oh, sorry. Let me go back.
Yeah,
I'm back.
Comment 4 talks about being justified in delaying transmission of information. First of all, in Georgia, this is comment 4. It's not comment 7. So we clearly are missing some of the comments that the American Bar Association.
The streamlined version, the leaner, meaner Georgia version.
We did not, of course, we don't ever adopt anything that the American Bar Association does without tinkering with it in Georgia, and this is one of the ways that we tinkered with this rule. But you can't, the sentence, a lawyer may not withhold information to serve the lawyer's own interest or convenience or the interests or convenience of another person. We don't have the end of that sentence, or the interest or convenience of another person. We just say you may not withhold information to serve your own interest or convenience. Now, the reason is not because we don't agree that you should be able to withhold information for the convenience of a third person. It's just because the ABA fairly recently amended this rule and Georgia hasn't gotten around to it yet. So just know that our rule differs there. There's another comment in the rule on diminished capacity that we're going to talk about next that I want to be sure that you know is not the rule in Georgia. Right. Because I do think that one might be a more significant difference. So anytime that you're looking at materials that are talking about the ABA model rules, know that Georgia's always got to mess with stuff. And what is the ABA model might not be the rule in Georgia.
So, and let me.
What does that mean when you say a lawyer may not withhold information? What does that mean within the context of deprivation cases?
Well, I think what it means is more what
So the question was kind of what does that mean? Because I don't think we recorded it.
Oh, okay. The comment over here about the importance of following up, for instance, and communicating with the client before, during, after, whatever, that you shouldn't say, oh, I get to delay passing on information because I don't feel like doing it right now. It's bad news and I don't,
I'm not comfortable.
I'm not comfortable with it, or I'm in a hurry, or I just don't feel like the drama of telling this child that she's going to be removed or, whatever. Your own convenience as opposed to what's really in the child's best interest. That's all.
And the other part, just to underscore a couple of other elements of it, I do think that additional language that, as Paula mentioned, is in the ABA rule but not yet in the Georgia rule, I think that, in my mind, sort of says just because it may be painful for mom to have Jamie know doesn't mean that Jamie shouldn't know. So I think this reference to another person is particularly apropos with these kinds of cases where what we're divulging could well hurt mother-child relationship or how Jamie thinks of mom, but that's not a good enough reason for us not to talk to Jamie or divulge the information to Jamie. And the other part I kind of want to put a highlighter on for a second as well is I think when you look at this comment, it also talks about the fact that if we think Jamie is going to freak out, react imprudently, maybe go and start harming herself because of the information that we're telling her, this comment doesn't say you never tell Jamie. It just says you look for the right time and place, and again in language that I think is particularly appropriate that I assume survives George's editing. I also think it's important to realize that there's a reference to looking to others to give you help. It may be that you don't have the professional expertise to know how to talk to Jamie about this issue, but that there are those with mental health training who can assist you in having that conversation with Jamie. So I think that there was a comment up front, or comment or question?
I think it was way back in the discussion, and I just
Want to start up at the beginning? So I come from California. No, go ahead.
With the way that you were questioning to get at the answer, to have the attorney answer that what Jamie's mother was really doing, and I was thinking that if you knew Jamie well enough, that those type of questions were typical of what you'd expect from Jamie, that Jamie was ready to go to court. And that
Yeah.
you wouldn't have
Thank
Jamie
you.
from court and hearing it in court, but you would tell him afterwards.
Right.
Seems like an
Right.
invalid.
So I think, and I'm not sure that that got recorded, I think that's an excellent point, which is if as sort of the gentleman and other individuals in the back row had pointed out, if this is very precocious, streetwise Jamie, you probably didn't want to be the messenger on this. Probably Jamie should have been there in court in the first instance. Because if Jamie kind of gets this and just needs to hear it from somebody that this is why I'm not going home, mom's turning tricks again, then probably Jamie should have heard it in the courtroom setting where there would have been a better ability for everything to lay itself out. I do want to turn to the issue of that Paul has mentioned a couple times. So what do we do about the fact that we have children? And let's assume now Jamie's not 11, but Jamie's 7 or Jamie's 6. How does that, Paula, change the calculus?
Well, the whole lawyer-client relationship typically is based upon an assumption that the lawyer and client can communicate with each other. That's how you form the relationship. Communication is essential to the relationship. The lawyer's actions can't be guided by somebody with whom the lawyer can't communicate. And so there is a special rule on representing clients under a disability or a client with diminished capacity. Georgia's rule, once again, has not been amended to reflect the most recent amendments to the American Bar Association's model rules. And this is one where we actually do have a proposal to amend the rule, but it hasn't been approved by our court yet. So if approved, and we are frankly a good year away from approval, if approved, the Georgia rule will be exactly the same and the comments will be exactly the same as the American Bar Association model, which is what's on the screen here. In the meantime, ours is a little bit less helpful because it doesn't provide, I think, the level of guidance that this rule and its comments provide. But the essence is the same. And I think what the ABA has done is revise the rule to address the concerns that people like you have when we talk about what Rule 1.14 allows and you make suggestions to us. So it's going to be a better rule, but right now it's not quite as good as what you see up here on the screen. Essentially what it says is that when you are representing somebody who, because they're a baby or a young child, or they might be an older person suffering from Alzheimer's. I mean, anybody who lacks the ability to make reasonable decisions in their best interest, that as far as you can, you treat them like any other client. So to the extent that they are able to understand what's going on and able to make decisions about the course of whatever it is that you're doing for them, then you treat it like any other lawyer-client relationship. When that is not the case, when you think that the client cannot act in their own best interest, is the language of B now for Georgia. Our B says, under those circumstances, you may seek the appointment of a guardian or take other protective action. Now let me just read Georgia's 1.14b. It says, a lawyer may seek the appointment of a guardian or take other protective action with respect to a client when the lawyer reasonably believes that the client cannot adequately act in the client's own interest. And, you know, most of the time, thankfully, I don't think it gets to the point where you need to have a guardian appointed to represent a client who's making sometimes irrational decisions. I'm not talking about a 3-year-old child, but you know, if you were representing an adult who suffers some sort of mental disorder that's controllable by medication or something like that, this rule would just say, treat them like any other client, make sure that they've taken their medication before they make any big decisions about their case or something like that. But if you are dealing with somebody who can't act in their own interest, you are allowed under this rule, and it's not mandatory, it's just, you know, you don't have to, seek the appointment of a guardian or take other protective action. You'll see in the ABA rule, they've clarified that there are a lot of things you might do short of getting a guardian for your own client in helping that lawyer-client relationship. You can consult with individuals or entities that have the ability to take action to protect the client. And then, when necessary, you could seek the appointment of a guardian ad litem, words that our rule says guardian. I think when I've advised people about this, I've told them you should do the least, I guess, the least constrictive thing for the client that you can. And so even though this rule talks about getting a guardian appointed, I would think that you would always try to make do with the guardian ad litem if you thought it came to that. Our comments now make it clear that before you seek appointment of a guardian, you can talk to individuals or entities who have the ability to take action to protect the client. And we would certainly encourage you to do so, because I do think in representing an adult client who is suffering from some sort of diminished capacity, it shouldn't be routine for you to go out and finding guardians for clients. Now, when you're talking about a child, I think sometimes it is routine, and depending on the age, it should be. But before it comes to that, and if there is no guardian for some reason in the case that you are handling, the comments to Rule 1.14 make it clear that you're allowed to use your best judgment. You're allowed to talk to other folks, to try to formulate a decision that's in the child's best interest, and if you decide that this is what's in the best interest of your client, you know, you put on a de facto guardian hat where there is no guardian and you're representing somebody who needs one. And the court either can't afford one or won't appoint one or whatever. So there's a lot of leeway in this rule for people who are acting in good faith, who are representing somebody who lacks capacity, where there isn't a guardian sort of reporting to the court. And I think quite often lawyers aren't comfortable with that, but you know, somehow the system sort of muddles through it and things happen and we don't usually hear about it. I don't know if it's because the client doesn't know enough to complain or what, but hopefully it means that cases are being resolved in the best interest of whoever the client is.
And I do want to spend a minute and look at a couple of these comments that Paula mentioned that are in the ABA model rules.
There's only one that we don't have, but go ahead.
Oh, okay. So do you guys have comment 1?
Yeah.
Okay. So I think this comment is particularly telling because it does reference the fact that even a child as young as 5 or 6 does have opinions that are entitled to some weight. So even if it's a situation where we've got a 5-year-old and we, you know, pretty much conclude that this 5-year-old, based on age, has diminished capacity, can't, fully articulate, make decisions. That doesn't mean that we completely shut out that 5 or 6-year-old or disregard them. We know from the rule that we're still to maintain as normal a client relationship as possible, meaning we communicate, we advise, we keep them informed, we protect attorney-client confidences, and also from this comment, we do give their views on the situation some weight. We don't just simply dismiss them out of hand. And I expect that this newer comment, Paula, is the one now that maybe hasn't yet made its way in.
Comment 6, we stop at 5.
Okay.
So it is that one that
Right, your roll goes to 5.
Yes.
The ABA's goes to 6, comment 6. So, I do think that this gives some added guidance in terms of the factors that can enlighten that decision. What do you look to in struggling with? Is this a client that I'm truly going to deem as having diminished capacity? Because again, realize that the rules don't tell us children always have diminished capacity. If anything, what the rules are saying to us is that it's not an either or, that there are gradations of capacity, there are gradations of how much weight we give to their views, but even children in certain circumstances should be viewed as having full capacity to participate in the process. And I think, again, it kind of encourages us to seek out help and advice from other professionals who might have a better sense of how to really assess this client and their capacity to participate in the process.
I think this is a real improvement to the rule, because lawyers all the time ask, well, what should I do? How do I approach this? Do I have to go out and hire a therapist to help me figure out if I'm doing what's in the best interest of my client? And the suggestions that are here, I think, are things that lawyers can read and understand and just try in evaluating what the client wants or how able the client is to make decisions in his own interest.
So I want to quickly just bring this hypothetical to a close and sum up some of the key things we've talked about in just a minute, because then I want to move to the in-camera issue. I know that we don't have too long left, and I really think that in-camera scenario is an interesting one to spend some time on. So I think we've talked about how critical it is to know your client. What does this client want? What does this client need? How might they react? What is underlying their desires, whether to be in court, to go home, or whatever else the issue pending might be? I think we've underscored the fact that there is no cookie cutter, all or nothing, right or wrong. Every hearing differs, every child differs, and sometimes the same child may have a continuum over time of where they come out on these sorts of things. We know that there's some factors that we need to be considering and that it's helpful to get the views of others. We know that we might be able to include a child, a youth in part of the hearing and absent them from another part that gets particularly difficult for them to be included in. And we know, above all else, communication is critical, as we said before, during, and after, that we need to be maintaining that channel of communication with the client. So let's now move to the second scenario. Now we have 8-year-old Barney. Not a green dinosaur. This is Barney the child. Barney's attorney says to the court, Barney really has a desire to talk to you, but he wants to do it in chambers. He wants to do it in private, kind of akin to the point that was made. He doesn't want to do it with mom right there, hearing what he has to say. Mom's attorney, not surprisingly, says, wait a minute. That's not right. I have a right, my client, mom, has a right to hear it and to know what Barney's saying, to be present for what's going on. Okay, what are some of the issues here that we should be considering? Okay, so we have the parent's right to confront the witnesses and the evidence against her. Clearly, number one thing to consider. Are there other rights, interests that we need to factor in?
Emotional impact on children.
Okay, we have Barney's interests. Barney's desire to give information to the court, Barney's emotional difficulty with not wanting to be there to provide this information in the presence of mom. Do we have any interest on the part of the judge? Okay, what might the judge be looking for in all of this? And then we'll come to your thought in a moment. I mean, does the judge want information? Yeah, you betcha. I mean, the judge wants to hear what Barney has to say, but I think we have some other concerns that we'll come to in a minute, ethical concerns that the judge has to deal with. Are there any other interests we may have? Yeah.
Depending on what type of hearing it is, it might not be whether the child's being removed from mom, but it might be whether the current placement, a type of review hearing that might actually have to do with the child's foster parents or their current placement or the services that DFACS is providing, that if the child's talking about those types of things, that they might feel like they have an interest as well.
All right,
SAG
so
might be objecting.
mom isn't the only one who wants to hear what's going on. I mean, we might have the department, we might have, there may be umpteen different family members or dad in the picture who feel a need to be part of it. Any other interests? What if the judge makes the wrong decision in the end? Who else might be interested in having the ability to hear what Barney said? Who's going to look over the judge's shoulder? The appellate court. Okay, is the appellate court going to be pleased as punch at the fact that there's some in-chambers conversation and they have no idea what happened in chambers? Okay, they have an interest. They have a desire to have a written record of what goes on in the courtroom. So, Paula, what about the ethical issues? Who has ethical issues here and what might they be?
The judge probably has more serious ethical issues than either of the lawyers involved in the case, because the Code of Judicial Conduct does prohibit a judge from hearing information ex parte. If you're going to hear information that might be persuasive in helping you form an opinion, then you're supposed to have everybody present so that they do have the opportunity to confront their accusers or whatever. And so I do think for the judge to do this in the face of objection by one of the lawyers could create an ethics issue for the judge. I mean, I think lacking a statute that allows it or a court rule or something for the judge to hang her hat on, that there could be a significant ethics issue for the judge. There's a corresponding rule of professional conduct that prohibits a lawyer from communicating ex parte with a judge about something substantively related to a matter that the judge is hearing without providing notice to everybody involved and the opportunity for them to be present if they want to be. It sort of recognizes that there are situations where you'll be in court on an emergency basis for a TRO or something like that, where the other side might not actually be there, but you've got the obligation to at least attempt to notify the other side and give them the opportunity to appear before going before a court on a substantive legal matter. So in this instance, the way that the hypo is set up, I don't think there's an ethics issue for the lawyer, because the lawyer has brought it up to the other side, obviously, and that's what's allowed mom's lawyer to object. But I do think that the lawyer kind of needs something to hang her hat on before she says okay.
Yeah, and just out of curiosity, how many of you have had judges who have done in-camera conversations with the child? Okay. That is usually what I tend to see, that it is, most of you raised your hand. So this is not an uncommon practice. Of those of you who have had it happen, how many of you have had it happen, but only if all the parties have first given their consent? Okay. So maybe half, and how many of you have had it happen without the parties being asked to give their consent? Okay, so realize that this rule that, as Paula said, is more the judge's headache, but obviously we want to, not be encouraging our judges to get into hot water, although maybe they're on their own here. They didn't show up today. But realize there are two carve-outs. If the parties give their consent, but I don't often see judges saying, okay, everybody good about this? Everybody want to give me consent? Is it informed consent? Have you talked to your clients? Is your client okay with it? It's also okay to do it if it's expressly authorized by law. Now, I have seen family codes that talk about an expressly authorized ex parte in-camera hearings with children in a family law context. Based on a search that I did a couple years ago, I did not see states where in dependency cases there were statutory authorizations. It happens all the time in dependency cases, but I think that probably it's not careful statutory authorization that's in place. I don't know if any of you know whether your state has a statutory authorization to do an in-camera hearing with the child. But again, I was not able to find juvenile codes that allow it, despite the fact that it is happening. So yes, a couple thoughts.
It's a question, actually.
Okay.
What if there is a criminal case? When I read that last bullet that was just up there, I read it differently than what it is. I read law enforcement, so then I thought, well, that's a good question. If there is a criminal case pending and the child's testimony might interfere with that, would it ever be permissible to allow the judge to hear a portion of that, so that it didn't incriminate, didn't alter the criminal case?
Yeah, now, and incriminate the child or incriminate mom? So, I mean, often when there are criminal cases, sometimes there's both.
Yeah,
I mean, there could be a
could be
criminal
both.
case pending, I mean, hopefully 8-year-old Barney isn't already looking at a criminal case, but, it may be that mom's been charged criminally with physical abuse, or a parent might be charged with sexual abuse of Barney.
Right, perfect example.
It may be that Barney's got a criminal case. I don't want to go home because, that's where I'm getting into gangbanging trouble, and Barney's got a criminal case pending. If it's the latter, I would encourage, any child's counsel not to be making a call on that unless they've consulted with Barney's criminal counsel. I mean, if Barney's got criminal charges pending, you want to be sure that whatever you do is fully protective of Barney's rights and interests in the criminal case. If there's a criminal case against mom, I mean, what are your thoughts? I don't know that necessarily means that Barney should be stripped of the ability to express a view, even though it may lock Barney in terms of Barney's witness testimony if called as a witness in mom's case.
Yeah, that's what I was thinking of. If this child had
Yeah.
information that they didn't really want out at the point
Right.
of a deprivation because the criminal case had not gone forward enough.
I mean, then there may be, I think, in the back there was a good articulation of all of the considerations to balance. I mean, then there might be another consideration, which is not simply mom's due process rights in this case, but also mom's right to have had the ability to confront evidence, that could be locking in a witness in the criminal trial. Again, I think that's a little more far-flung right, but it's an added consideration. So let's say your judge decides that she really wants to hear from Barney. What might you want to do to protect the record a little bit? Any thoughts? I mean, we talked about one of them, consent, right? Pardon? Consent, clearly consent, and not just mom. I mean, I think the point was well made that there may be other entities who have an interest in being there. So everyone really should be consenting to the in-camera conversation. Yeah?
Clear one thing up.
Yes.
When I was talking about that TPR yesterday where the kids testified and 2 of them didn't want to testify in front of their mother, and I said they did it in camera.
Yes.
I mischaracterized that because what happened was they didn't want to testify in front of their mother. The mother and the attorney agreed that she would leave the room, but the attorney would be there. It was done in court, on record. The attorney had the opportunity, it was regular questioning, and the attorney, had the opportunity to cross-examine,
mom was,
the children. So it wasn't the children going back into the judge's chambers and giving testimony.
Let's have a little chat. And
Clear that.
perfect, because you actually threw out a couple of the other thoughts here, which is if you're going to do it, try to have a record made. And even if it's a judge who just really likes to go into chambers, take off the robe, and be cozy with Barney, not look threatening to Barney, and doesn't want to have a court reporter in there, then consider at least when you get back into court, say, Your Honor, when we were in chambers, the following issues were discussed. Just try to have some kind of a verbal memorialization, but ideally there's a record made. And, and then the transcript needs to be made available to mom and mom's counsel. I think, as you pointed out as well, if mom is the one who it's threatening for Barney to talk in front of, You might want to have closed circuit TV with mom in the courtroom so Barney doesn't see mom right there, or just simply absent mom with consent from the courtroom. So at least allow the lawyers to be part of the information, the revealing of the information from Barney. Consider when in the case it is. If it's post-TPR, then I think that it's less of a concern. Frankly, probably there's not going to be an in-chambers conversation, but sometimes judges still prefer, even post-TPR, to sit around their round table in chambers, take off the robe, and talk to now 17-year-old Barney and say, how's it going? How's school? We've got to do some permanency planning. What's up with you? What do you need from us? So again, you may be less concerned at that stage of a case having an in-chambers conversation. And then one thing that they do through some rules in another state that I looked at is they give the questions or a list of topic areas to everyone so that everybody knows what Barney's going to be talking about. So I think those are a couple of issues just to think about. As you can see, there were some other scenarios, but this has been a great conversation. You should know that the last time this was presented, they only got through scenario number 1, so you guys doubled it. But I always have more ready to go just in case. Just to sum up, I think as I indicated at the outset, there is obviously, tremendous commitment around the nation to this work that's done. These are unique courts. These are unique cases. There are unique roles that judges and lawyers find themselves in, but we can't lose sight of ethics rules as we fulfill these kinds of roles. Sometimes it's a less formal court setting, but again, you have to really keep a watchful eye on the rules of ethics because they don't apply with any less force, as informal, as unique, as wonderful as the job may be. On the upside, I think that this is an area where we have a tremendous opportunity to make a difference on behalf of those who have such resilience and such ability to hopefully move beyond the difficult circumstances that they've been cast with. So I think what we do truly does change lives every day. And in so doing, I love this quote from our Chief Justice in California, who's been very active on behalf of children's issues. I really think it does, as he so well put it, cast who and what we are as a society and define our future when we do this work on behalf of children. So thank you all for the work that you guys do every day and for being engaged and attentive and participatory. And we will stick around in case any of you have questions that you want to talk to us about.